From the opinion pages of the Wall Street Journal, this is Potomac Watch.
The political battle over the Supreme Court shows no sign of ebbing as Democrats escalate their attacks, including demands that conservative justices recuse themselves from hearing certain cases. What's the logic behind this new progressive demand, and what impact would it have on the court and an independent judiciary? Welcome. I'm Paul Gigot, editor of the Journal Opinion Pages, and today I'm joined by James Taranto. He's the Journal editorial page features editor who's responsible for the op-eds and editing the columnists. But he's also a student of constitutional law and the Supreme Court, and was one of the Journal editors who recently interviewed Justice Samuel Alito for 4 hours over two occasions. The two interviews, one in April and one in July, both on the record, both made news, and they were especially valuable, in my opinion, as an insight into Justice Alito's jurisprudence. But the media and the Democrats, I don't mean to be redundant, didn't like that he spoke with us or what he said. And we'll talk about how this is playing out now politically. I should add that I personally attended the second of the two interviews, which took place in New York. I did not attend the first one in Washington, D.C. James was accompanied in those interviews by David Rivkin, who is a frequent contributor to the Journal, a lawyer in his own right, an appellate lawyer. And we'll talk a little bit more about David. But how did these interviews happen, James?
Well, David called me last winter and said, what do you think of the idea of a weekend interview with Justice Alito? And I thought it was a great idea. David always writes with a co-author, and so I volunteered to be the co-author. And then David set it up and said, come to Washington in April. The original plan was to do two interviews, one in April and one after the term ended in July, and write it up as one article. We were waiting till July so that we could talk to him about decisions the court made at the end of the term, which he obviously couldn't discuss in April. But then we did the April interview, and it turned out there was news in there, so we got it out as quickly as possible and ended up doing two interviews.
And that news was the fact that he had said that he thought that the person who had leaked the draft of the Dobbs opinion before the opinion was actually released was somebody on the left who wanted to upset the Dobbs opinion.
Well, not only that was what type of person he thought it was, but he thinks he knows actually who did it, although he wouldn't say.
Right. Well, which was prudent of him. But that caused consternation because apparently he's not supposed to say that. The court, by the way, has not ever disclosed who did it. They say they don't have enough evidence to show that.
Yes, and Justice Alito also said he doesn't have enough evidence to make a public accusation.
Right. So let's talk about this latest flap, which the second of the interviews, which was interesting. And Justice Alito made some news here, too, in that he said that, in particular, that he did not think that the Congress, the United States, as a constitutional matter, has the authority to regulate how the Supreme Court operates. He said, in particular, no provision in the Constitution gives them, that is Congress, the authority to regulate the Supreme Court, period. End quote. Now, he did concede also that Congress can affect the budget of the court, which we know it can. The justices go before the Congress and ask for their budget request every year. But when he talks about regulating the court, he means, I think, the processes of how the court operates and goes about its judging.
That's right. Congress can't set rules for how the court does its work. And they haven't done so before. There are ethics rules that apply to lower courts as well as executive branch officials. They don't officially apply to the Supreme Court, although Justice Alito said that he and all the other justices voluntarily comply with them. That's why we have these annual disclosure forms from the justices. And there are rules about recusal that are sort of vague, and the justices follow those, although recusal is a little bit different from the Supreme Court because there's only one court, only 9 justices.
I want to get into that. I want to get into that because there are a couple of elements to this ethics regulation per se. One is ethics rules. The Democrats have introduced a bill, passed it through the Judiciary Committee in the Senate, which would make lower court judges arbiters of whether or not justices have violated the rules if there's a complaint. I think Alito was referring in part to that kind of regulation. But the second thing gets into recusal. And this is when a judge decides that there is an actual conflict of interest or the appearance of a conflict, and therefore should not hear the case. This is rare because of the points you made, particularly regarding the Supreme Court, that they only have 9 justices. And so if one of them recuses itself, it could have a 4-4 case.
Yeah, and there's the idea of the duty to sit. If there's not a compelling reason for a justice to recuse himself, he is obligated to sit on the case because there's no one else who can do it. There are only 9 justices.
Just to elaborate on that, if there's a 4-4 ruling, for example, it means there's really no clear judgment in the case, and both sides of the argument are in that sense cheated of a clear verdict.
Right. It means the lower court opinion stands, but the Supreme Court expresses no view on the subject.
Right. So just to make clear, all 9 justices are on board with your point about the duty to sit. How do we know that? Well, we know that because in April, the Chief Justice of the Supreme Court, John Roberts, sent a letter back to the Judiciary Committee in response to its request that he appear to be berated by the Democrats over ethics. And he attached a statement on ethics principles and practices that elaborated on how they follow ethics rules now, as well as the recusal question. And that statement stated, justices have a duty to sit that precludes withdrawal from a case as a matter of convenience or simply to avoid controversy, unquote. And that last bit, simply to avoid controversy, is very important because, of course, in our current hothouse political environment, a lot of people like to create controversy for the sake of trying to influence the court. And if that it extends to actually whether a justice can sit on a case, that really gets to the heart of the judicial role.
Yeah, and ginning up controversy to discredit the court or influence the court is like half of what the Supreme Court press does.
Explain why the issue to sit or not to sit, to hear a case or not to hear a case, is something that gets to the heart of judicial independence.
Well, because it's ultimately a judgment. It's a decision about, can I render an independent verdict here? Can I separate myself from whatever interest I may have in the case or whatever apparent interest I have in the case? There's no one else who can really make it. And the idea of having lower court judges make it for the Supreme Court is crazy because lower courts are lower courts. They can't tell the Supreme Court what to do. That's the whole point of having a hierarchy of courts.
Well, they also, the lower courts have cases that Supreme Court justices rule on. So you could get a lower court judge. And by the way, this idea that lower court judges would be the arbiters of recusal decisions is in Democratic legislation that I referred to that passed the Judiciary Committee. So this isn't a fanciful idea.
Yeah.
This is something that they are proposing.
And the other way of doing that might be for the justices' colleagues to make that decision by majority vote. But again, then you get into situations in which the colleagues who have an interest in the case coming out a certain way might vote a certain way. It causes more questions about the integrity of the judiciary than it resolves.
The 9 justices actually said precisely that in their statement of ethics principles and practices that they submitted to the Judiciary Committee. They said letting the full court or a subset decide on recusal, quote, would create an undesirable situation in which the court could affect the outcome of a case, unquote, by selecting which justices could participate. The idea would be this was add a new element of political maneuvering inside the court, as the justices, particularly a political justice like, say, William Brennan, who is known for his internal lobbying, could say, yeah, let's get together and exclude Alito here or exclude Kagan or exclude Justice Barrett because, she might not be with us, right?
And by the way, there are political checks on the court. The justices are appointed through a political process. The president chooses them and then the Senate confirms them. And if in cases of actual misconduct, they're subject to impeachment. But the supermajority requirement in the Senate to convict and remove an official is protection against precisely this sort of partisan crusade that the Senate Democrats are on right now.
Let's take up another element of this. Justice Elena Kagan spoke up on this, James. Last week, she was reported by Politico. She was speaking to a judicial conference and was asked about Justice Alito's comments in his interview with us. And she said the press reported this as disagreeing sharply with Alito. And she was quoted as saying, "We're not imperial," which Everybody knows they're not imperial. The press made much of this. She was asked, can Congress do various things to regulate the Supreme Court? I think the answer is yes. But she went on to say that can Congress do anything it wants? Well, no, there are limits here. No doubts. It strikes me, James, that even though this wasn't elaborated on more in terms of the specific things Congress might do or not do, Kagan isn't that far away from Alito.
Well, there's nothing she said, from what I've heard, that contradicts what he said. She's a bit vaguer about how far she would go, but he concedes in the interview, we didn't quote this part in the article, but he concedes that Congress has the power of the purse, and so they can exercise control that way. Justice Kagan doesn't dispute Alito's point. She may disagree with it, but she doesn't dispute it in this quote that the Constitution created the Supreme Court. Unlike the lower courts, unlike administrative courts, the Constitution created the Supreme Court, and therefore it is an independent branch of government. And I kind of suspect Justice Kagan would agree with that point if you pressed her on the matter.
Well, particularly on recusal, I would think. Because if you begin to make kind of open season every time there's a case so that somebody could say, aha, I spy, appearance of a conflict there when any kind of justice involved, whether it be a personal association with somebody or for whatever reason, and then you turn that over to a lower court panel, essentially, to determine and make a judgment about, it's going to be open season on liberal as well as conservative justices. The idea that only the left would attack this question is, I think, silly because you've got all kinds of conservative activist groups which would try to disqualify the liberals.
Yeah, and you could even imagine an elaborate conspiracy in which somebody befriends a justice years ahead of a case in order to disqualify him down the road from hearing a case on a particular subject. And of course, some of these constitutional battles go on for decades before they're resolved.